for the first counsel, 14 for the second, and a 1-minute rebuttal.
1-minute rebuttal. Okay. And for the appellees?
Hi, I'm going to do 16 minutes and my co-counsel is going to do 14 minutes.
14. And that's going to be 16 minutes first?
Yes.
Okay. 16 and 14. And so for all of you, I'll be holding up the cards. Is that okay? Okay. Great. I think that's, yeah. Do you guys have any questions, or you guys have been through this, so. Great.
So are you ready now, Juliana?
Yeah, I have everything I need. If you guys are ready, we can start formally.
Sure, ready to start.
Yeah, I have everything I need. If you guys are ready, we can start formally.
Sure, ready to start. I'm sorry, I'm having a little bit of an echo on my end. If I could just hop off and rejoin. Is that all right?
Yes, I'll let you back in. Go ahead.
Thank you.
Excuse me? Quick question. Mine keeps saying that breakout rooms, that I need to wait to be assigned to a breakout room. Do I need to do anything different or just X
No,
that
no,
out?
that was not for you.
Okay, thank you. Quick question. Mine keeps saying that breakout rooms, that I need to wait to be assigned to a breakout room. Do I need to do anything different or just X
No,
that
no, that was not for you.
out? Okay, thank
Do you also hear that echo?
I heard that echo.
Okay, so
Thank you, bailiff. Okay, ready to start. Good afternoon, Chief Judge, Your Honors. May it please the court. My name is Catherine Hunter.
Oh, I'll start.
Oh, excuse me.
That's okay. For the INTA bailiff, do we have everybody?
I'm not sure all the judges are on.
Okay, yeah.
Oh, they are.
Yes.
Yes.
Can you let me know when everybody's in our room?
You could start.
Oh, so everybody's here. Okay,
Yes,
great.
everyone is checked in.
Okay, wonderful. Good morning, good afternoon. Hear ye, all persons having business with the United States Court of Appeals for this circuit draw near. Give your attention and you shall be heard. The court is now in session. The Honorable Mark Thurman, Elizabeth Dunn, Jonathan Hudis, and Elizabeth Winter presiding. Norman Herman Enterprises, LLC, DBA, The New Norm versus Natural and Organic Real Meat Meals, LLC. Is Team ATL4 for The New Norm ready?
We're present.
Is team for the natural and organic real meat meals ready?
Yes, thank you.
All parties ready, Your Honors. Counsel, there are 3 issues on appeal raised by the plaintiff. For purposes of our arguments today, the defendant, The New Norm, will be deemed the appellant. because the court granted natural and organic real meat meals, natural and organic, motion for summary judgment and awarded it $3 million. The appellant will argue first in each round and may reserve up to 5 minutes of its time for rebuttal. The plaintiff, natural and organic, is the appellee. Our rules do not allow for rebuttal arguments by plaintiff, appellee, natural and organic. Each party will have 30 minutes to argue. Counsel for the new norm may reserve up to 5 minutes for rebuttal. The bailiff, I will hold up the time cards labeled 5, 3, 1, and 0 when there are 5 minutes remaining, 3 minutes remaining, 1 minute remaining, and when time is up for each participant. During rebuttal, if any, the same timekeeping procedure will be applied. The new norm, will you be reserving time for rebuttal?
Yes, we'll be reserving 1 minute for rebuttal.
How will you divide your remaining time?
Our remaining time will be 15 minutes to start on issue 1 and 14 minutes for issues 2 and 3.
Natural and organic, how would you divide your time?
I will be speaking for 16 minutes about issue 1, and my co-counsel will be speaking for 14 minutes about issues 2 and 3.
Counsel for appellant, you may begin.
Thank you, bailiff. Good afternoon, your honors, and may it please the court. My name is Catherine Hunter, and together with my co-counsel, Daniel Kaltman, I represent the appellant in today's case, Mr. Herman Norman. I will be arguing issue 1 on likelihood of confusion, and my co-counsel will argue issues 2 and 3 on willful infringement and the award of profits. Today's case is about protecting any utopian's ability to make their way in small business. In 2016, appellant Mr. Herman, known to all in his life as Norm, took charge of his life and health and got in shape. To share the rewards of his journey with utopians, he opened a small business offering exercise classes with the unique twist of involving dogs. His own dog, Bingo, was there by his side and had been a huge part of Norm's success. Norm was the face of his business, hosting all the classes himself, and so he chose a play on his own name, The New Norm. Because he streamed all of his classes online, the name also reflected how the classes fit into the new normal thrust upon utopia by a devastating global pandemic. We respectfully ask this court to remand this case because Norm Dog Food failed to meet the standard for summary judgment. This court should allow the jury to consider the material issues for which there are genuine disputes. Turning to issue 1, likelihood of confusion is a threshold issue. There can be no liability under Section 43A of the Lanham Act if there's no proof of likelihood of confusion.
Counsel, wasn't there proof of actual confusion in this case?
Yes, Your Honor, there is some evidence of actual confusion in this case. However, it's a very small number. And in door system versus Proline door system, the Seventh Circuit held that when weighing the weight of actual confusion, the court should do so by comparing that evidence against the total number of opportunities for confusion. And that court held if there's a very large number of transactions and only a small handful of instances of confusion, the confusion has little weight. And in that case, when the plaintiff's evidence amounted to no more than 2 confused customers, not unlike the evidence in this case, the court asked out of how many thousands and held that the evidence was not enough to create likelihood of confusion. Here, the facts are very similar. We see on page 6 that Apelli is a national brand that takes in thousands of national online orders. And Norm's business has also grown quickly to reach thousands of customer transactions online. So this court could find the confusion in this case de minimis and disregard it, especially because, and I'll get to this point in much greater depth, Mr. Norman did not sell dog food. And so those instances of actual confusion did not affect any customer purchase decisions.
But he did sell did put online dog recipes, correct?
Yes, Your Honor, he handed out recipe cards in some of his classes as sort of a takeaway, but it was not the primary part of his business. And I will also get to the relatedness of the goods as part of my argument and discuss how these two goods are not related. There are 6 factors in total. I just covered 1, actual confusion, and I will cover 5 more. Even if some of the factors weigh in favor of likelihood of confusion, the relative importance of each one is flexible, and the courts consider all of the factors and weigh them in light of their circumstances. I'll turn to the similarity between the marks and show that they lack enough intrinsic similarity to support the district court's summary judgment grant. The similarity factor is the most important one here. In Anheuser-Busch Incorporated versus L&L Wings, citing the Pizzeria Uno factors, the Fourth Circuit held that without enough intrinsic similarity, none of the extrinsic factors, including relatedness of the goods, the trade channels, and the strength of the marks, can stand on their own to support likelihood of confusion. Courts consider names and logos in their entirety as they would appear in commerce in the marketplace. AMF Inc. versus Sleek Craft Boats tells us the relevant factors for similarity are appearance, sound, and meaning. Appellee focuses on the shared marks in the words, but that is not enough. In Nutrisystem Incorporated versus Constant Industries, the words Nutrisystem and Nutritrim failed to meet that standard. The court
Excuse me, counsel. I guess I'm a little bit surprised to hear you say that you think that the dissimilarity of the marks is one of your strong points. I am old enough that I remember the new Coke, and I pretty much was clear that it was coming from the same place as the old Coke. And so your point here is that saying the new norm differentiates it from norm?
Your Honor, your question touches a bit on the strength of the marks. And in that case, the word Coke is entitled to a much stronger degree of protection from the courts because it is either an arbitrary or a fanciful mark.
Well, you know, counsel, I think I disagree with that. I think that I'm talking about the comparison of the marks, and when you say norm and the new norm, the new is not something that changes the commercial impression of what follows. Whether it's strong or it's weak, it's the new version of the same thing. But carry on, thank you.
Your Honor, I think your question is also going to be addressed by talking a bit more about the standard for similarity between the marks and pointing to some of the other things that the court considers when looking at the entirety of the marks as they appear in commerce. And a couple things to point to are colors and logos being important in that comparison. GoTo.com versus Walt Disney Company held that emphasized visual, immediate, striking similarity between the two marks in that case. And that was because they shared similar lettering colors, background colors, fonts, and shapes. And on page 17 of the record, you can see the many differences in appearance between the way these parties' marks appear in commerce. The packaging on Appellee's dog food is yellow, it has lowercase letters and a black cartoon dog, whereas our mark is in the uppercase and it emphasizes real life photography of Norm and his dog. And we would also point to answer your question to the case AMF versus Sleek Craft Boats again. In that case, the names were quite similar, just like we have here, but the marks appeared in brochures and things like that, along with many other visual markers, and the court emphasized those visual markers as well.
So counsel, just to follow up on my colleague's question, we can judge the similarity of the marks based upon appearance, sound, meaning, and commercial impression. So if you were to ask for your client's services or products, you would ask for the new norm. And as Judge Dunn emphasized, the new is really not going to be so source identifying. It's going to be norm. And whereas the plaintiff's mark is norm, I appreciate your comment on the differences in the packaging, but what about when customers ask for the product?
Your Honor, we don't have any evidence in the record of that coming up with customers asking for a product. And it's also worth noting from a policy standpoint that finding these marks confusingly similar would essentially be suggesting that a small business entrepreneur could be barred from using his own name and describing what the product did for him, just because another phonetically similar business is out there. And that would be a standard that would really stifle the ability of people in this district to do business as they're entitled to.
What about the trademark owner's right to protect her trademark, which is federally registered?
Your Honor, we're not suggesting that the mark holder has no way to protect her rights. I would turn now to the three extrinsic factors to get into that in a little greater depth and explain how these products are not related and their retail outlets are quite similar. So the original mark holder has plenty of right to protect the mark in.
Could I ask a question? Before you move on to the other factor, did you say earlier that you view the factor, the similarity of the marks, as the most important factor in the case?
That's correct. And the citation for that is AMF Incorporated versus Craft Boats from the Ninth Circuit. Turning now to the extrinsic factors, first turning to the strength, Your Honor mentioned that, of course, Apelli's mark is federally registered. But it's worth noting that commercial strength is part of the analysis as well, and that depends on the length of use, the extent of advertising, and whether a conscious connection exists in consumers' minds. And the source for that is Hornady Manufacturing Company versus Double Tap Inc. Apelli is a relative newcomer in the marketplace and has only been in business a few years with a modest social media advertising budget. So there is no evidence of a conscious connection in the public's mind. And with regard to the trade channels, the next factor I will cover, advertising and retail outlets are important for this court to consider here. Exxon Corporation versus Texas Motor Exchange of Houston held that differences in the nature of the retail outlets that would make it difficult for customers to mistake one for the other also reduced the chance of likelihood of confusion. In that case, one party sold their products in large gas stations and the other operated out of a warehouse style building. And the court held that it would be difficult to mistake one for the other. The facts of this case are very similar. We see on pages 5 and 9 of the record that Apelli's retail outlet is an animal hospital and ours is a fitness studio. And it would be very difficult to confuse those based on the vastly different stores. And there's no evidence any customers did confuse them. We concede that the parties here.
Excuse me, counsel. I would like to ask, but isn't there in fact a couple of customers of appellant ask about the Norm dog food when they went to the exercise class?
Yes, Your Honor. There are a couple instances of actual confusion. As I covered, those pieces of evidence are de minimis in this case because there were thousands of opportunities for where confusion could have arisen, but did not.
Okay, thank you.
Returning to the trade channels, the parties do use the same advertising media here. However, that similarity would apply to most businesses today who are on social media and should not affect this court's analysis because it doesn't mean that customers can't tell these two different products and businesses apart. And so in sum, the trade channels should not weigh in favor of likelihood of confusion either. And moving quickly through the relatedness of the goods, I've covered this a bit in response to Your Honor's questions, but the relatedness depends on whether the products are the kind the public would attribute to a single source. And this is a very low threshold that has been met when products are plainly very different and the public can distinguish them. In McGraw Edison Company versus Walt Disney Productions, even two types of products as different as electrical fuses and consumer video games were held to be the type of products the public could attribute to a single source. And so on policy, this is a low bar, and this court should again take note that Norm did not sell pet food. And trademark rights in this case shouldn't be extended so far as to limit the ability.
Excuse me, counsel. I'm somewhat troubled by the fact that your client actually created the link between dog food and fitness classes, which are, as you say, very different in nature. He's the one who carried his dog around. He's the one who put recipes on his website. I mean, wasn't he creating the link to fitness and dog food with the way he promoted his mark?
No, Your Honor, we would disagree. I'll answer your question with the final factor of intent and conclude that way. The relevant intent and creating the connection is one of deliberately sowing confusion in consumers' minds, according to Amstar Corporation versus Domino's Pizza out of the Fifth Circuit. And that case asks whether the newcomer is trying to pass off his goods as that of the senior mark holder. And Mr. Norman did not try to promote confusion or disguise his business as anyone else's. We see on page 9 that he corrected the customers who were momentarily confused, and he did all he could to differentiate his business in this case. Thank you.
Thank you, counsel.
Chief Judge, Your Honors, good afternoon, and may it please the court. My name is Daniel Kaltman, and my co-counsel, Catherine Hunter, has previously addressed the likelihood of confusion issue. I will now address the remaining two issues, willful infringement and profits as the remedy in this case. Today's case is about a small business owner attempting to start his own pet-friendly business to pursue the American dream. Appellant respectfully requests that the district court erred in granting summary judgment for the willful infringement issue and abused its discretion in granting $3 million in profits.
Counsel, if I could ask a question. When your client adopted the new norm, isn't it true that his dog considered norm dog food his favorite? Your client ordered the dog food online, received a cease and desist letter and didn't pay any attention to it. And even when he adopted the mark, he did not seek counsel in clearing the mark. Aren't those factors that could go to willfulness and ultimately the disgorgement of profits in this case?
Yes, Your Honor. I will begin with the issue of willful infringement and address all of those issues in this case in turn. Courts have defined willfulness as conduct showing a deliberate and intentional design to cause confusion to deceive purchasers. To prove willful infringement, a plaintiff must show that 1, the defendant was actually aware of the infringing activity, or 2, the defendant's actions were the result of willful blindness. And here, the district court erred in finding willful infringement in this case because Mr. Herman did not have actual knowledge, or in the alternative, Mr. Herman was not willfully blind of his infringing use. First,
well,
Mr. Herman.
Counsel, just to go back on the question I just asked you, doesn't the record sort of say the opposite? That indeed he knew about norm dog food and he did proceed without counsel, and then even after a cease and desist letter from the plaintiff?
Yes, Your Honor. Although Mr. Herman was aware of Miss Yee's business because he did occasionally purchase pet food at Miss Yee's store, he did not know the business to any willful level, which must be as per the definition of willful infringement, deliberate and intentional. Mr. Herman did not shop in Miss Yee's physical store. Mr. Herman did not have any knowledge of overlapping customer lists. And as my co-counsel previously stated, Mr. Herman does not sell pet food in his store. Yes, Your Honor, the record on page 9 does state that there were multiple customers who were confused, but there is no indication that there was any intentional or deliberate actions from Mr. Herman that caused this. In fact, he even corrected
Counsel, if I could interject on that specific point. When he found that some people were confused by this, and you acknowledged that he discovered that at some point, did that not put a burden on him to do something to stop that, to prevent any further confusion? How does that relate to his state of mind? Whatever he thought prior to that, once he knows people are being confused, at that point, isn't he at least being willfully blind of a problem?
No, Your Honor, we would disagree with that statement. My co-counsel previously addressed the de minimis aspect of the few instances here of actual confusion. And like Your Honor mentioned, he even corrected the few customers who inquired about the affiliation. And so his actions would stem toward that there is no intentional or deliberate actions from him that caused the confusion here. Your Honor,
Excuse me, counsel. After, I mean, he was selling fitness classes, which
Your Honor, I don't believe I heard the end of your question.
Hi, I'm sorry about that. I had a glitch on my screen. Your client found out that people were being confused and didn't remove the dog food recipes from his website. I mean, someone said, "You're selling dog food." He said, "No, I'm not," but he had dog food recipes on his website. So I guess I don't see how that isn't deliberate, to follow up on what Judge Thurman said.
Your Honor, further to speak on the issue of the listing on the website and the physical proximity between the stores here, there was no deliberate action from Mr. Herman to create that affiliation here. Mr. Herman did not know of the business of Miss Yee's store to any willful level, as I've previously explained. And further, the physical proximity in the stores here were located near each other. However, Mr. Herman did not know of the physical proximity. On the record on page 9, it states that he did not know that the Norm store was even in the same neighborhood or down the street. And as NAS Import versus Chenson from the Second Circuit held that knowledge of the proximity of the physical store locations did support actual awareness, but in this case, the stores were located just one block from each other, and importantly, the alleged infringer knew of that before opening the store. And here we have the opposite, Your Honor. Secondly, the district court erred in finding Mr. Herman liable for willful infringement, even under a willful blindness theory. Mr. Herman took initial and reasonable steps to search for and evaluate his business name. In AC Leg Packaging versus Old Plantation Spice, the court stated that the defendant who failed to take reasonable due diligence may be liable for willful infringement. Here, Mr. Herman took reasonable due diligence as any ordinary business owner would. Per page 9 of the record.
What was that due diligence, counsel?
Yes, Your Honor. Per page 9 of the record, Mr. Herman conducted an internet search for any related names similar to the new norm. Also on page 9 of the record, Mr. Herman consulted his friends before deciding and adopting a name. This was not an impulsive.
He did not consult counsel, did he?
No, Your Honor. However, hiring expensive legal counsel at the start of his business would not have been necessary in this case. It was reasonable for a new small business owner excited to start his new business and benefit the community in a helpful way to conduct an internet search on his proposed name, ask his friends, and then adopt the name. A higher standard would place burdens on newly formed businesses to hire expensive legal counsel, conduct all of these official searches here. And as my co-counsel stated, Mr. Herman did his due diligence in figuring out the name of his business. Further, Your Honor, this brings me to my next point on Mr. Herman's efforts in establishing his new business and his efforts in hiring members of the community, not in paying legal expenses. Further, Ms. Yee did not have trademark counsel when she started out. There is nothing against a pro se defendant, which brings me to the point of the cease and desist letter here. There's no indication from any case law or any circuit that states that Mr. Herman was fully required to hire legal counsel. Now we will discuss the final issue of the recovery of profits as the district court's choice of equitable remedy in this case. A district court's amount of remedy under the Lanham Act is reviewed for abuse of discretion, and the granting here of $3 million in profits is a clear abuse of discretion. First, equitable remedy of profits is unavailable in this case because there is no willful infringement under issue 2. Second, without a finding of willful infringement, a recovery based on an unjust enrichment theory is also unavailable in this case because the products do not directly compete and there was no siphoning of sales.
Counsel, if I could, before you move on to that, you're arguing that there was no willful infringement. We understand that. If we disagree with you on that, if we affirm that there was willful infringement, do you lose on the profits issue?
No, Your Honor. Even if this court does find willful infringement under issue 2, there are certain mitigating factors in awarding profits that weigh in appellant's favor. So section 1117 of the Lanham Act states that in assessing profits, the plaintiff shall be required to prove defendants, and the defendant may prove all elements of cost or deduction claimed. The court in George Bash versus Blue Coral from the Second Circuit stated that those deductions exist as mitigating factors when awarding profits based on willful infringement. These mitigating factors include the degree of certainty that the defendant benefited from the unlawful conduct and the role of the particular defendant in effectuating the infringement. Both of these mitigating factors are present here, and thus a deduction should be warranted even if this court does find willful infringement under issue 2. For the first factor, the degree of certainty of Mr. Herman's benefit in any infringement is attenuated at best. There is no evidence in the record suggesting Mr. Herman's profits were increased or whether the alleged infringement attracted more customers to his store. Further, the second factor, there is no evidence in the record that Mr. Herman's direct actions effectuated the infringement here. Secondly, it is
What
correct
about the
that
evidence? What about the evidence, counsel, of reckless disregard or willful blindness, particularly when there was evidence of actual confusion brought to his attention and he got a cease and desist letter, which he ignored?
Yes, Your Honor. As I previously stated, Mr. Herman's actions were reasonable given the circumstances in this case. Mr. Herman was not expected nor required to hire his legal counsel at any stage of these facts. And so the same stance would apply to the profits remedy as well.
Excuse me, counsel. I think for me, one of the issues is the fact that on adoption, I mean, this is a man who talked to his dog and said, here's your Norm from Norm. I mean, he adopted his mark fully aware of the fact that Norm was a dog food name and that he was then going to be using his dog to promote his own services. So even if, if I agree with you that that hiring counsel isn't determinative, how do we move away from the fact that perhaps all of his profits are attributable to the fame that the Norm dog food had, which he was trying to attach to himself through the use of his dog?
Well, Your Honor, we would move away from that because there is nothing in the record that deciphers the profit number here. The general rule, yes, Your Honor, is the full amount of profit unless there are deductions claimed. And we would ask this court to remand for consideration of those deductions in light of the mitigating factors of George Bash versus Blue Coral. Secondly, it is correct that the Supreme Court recently stated in Romag Fasteners versus Fossil that even without a finding of willful infringement, a plaintiff may recover profits in an alternative theory, such as unjust enrichment. However, to support an unjust enrichment claim, Electrolux versus Armatron International from the First Circuit held that the plaintiff must prove that the products in question compete and that there was a siphoning of sales. 7-Eleven versus Z11 held that the court rejected an unjust enrichment claim because there was no evidence suggesting any siphoning of sales from 7-Eleven from the opening of Z11. Here, as my co-counsel previously addressed, Mr. Herman's products do not directly compete with Norm. Mr. Herman does not even sell pet food in his store. He sells human exercise classes, which is an entirely different submarket. There is also no proof in the record that shows Mr. Herman's stores diverted any sales from Norm. The record does not show any accounting records from Ms. Yee's stores to analyze whether any of her sales or her customers were diverted from her store to Mr. Herman's store. And to remind your honors, $3 million is all of the profit Mr. Herman has ever earned from his small business. The district court thus abused its discretion in granting Norm equitable relief in the amount of $3 million. Thank you.
Good afternoon, and may it please the court. My name is Elizabeth Charles, and along with my co-counsel, Mr. Kilkoff, I represent the respondent, Natural and Organic Real Meat Meals, aka Norm. Your Honor, this is a case about protecting a hardworking business owner from a man who only cared to take. First, we're asking you to affirm the lower court's finding that there is a likelihood of confusion between Ms. Ye's mark, Norm, and the petitioner's mark, the new Norm. We're asking you to find that all 6 factors of the likelihood of confusion test weigh in Ms. Ye's favor. And we're asking you to... Yes, Your Honor.
All right. If this was an appeal after trial, and you had findings of fact from the judge or a jury verdict based upon a full discourse of the record, that might be one thing. But we have here an appeal after summary judgment, which is a different standard. Is it your position that all of the likelihood of confusion factors are so in your client's favor that there are no genuine issues of material fact left remaining?
That is what we're arguing, Your Honor. And the district court, in fact, found that 4 of these factors, whether or not there was a relationship between the parties' trade channels, that Ms. Ye's mark was strong, that there was evidence of actual confusion, and that there was intent by the newcomer to derive benefit from Ms. Ye's mark's success, already bore no true issue or genuine issue of material fact.
What about, as your opposing counsel raised, the apparent lack of overlap between the products, the services, and the channels of trade?
Correct, Your Honor. The district court did find that this factor did not weigh in Ms. Ye's favor, but we are arguing that this factor does, in fact, weigh in Ms. Ye's favor, and that the district court found this factor to not weigh in Ms. Ye's favor incorrectly. The reason that we're arguing that is that while the district court identified that pet food and exercise classes for pet owners and their pets may not be inherently related goods or services, in order to satisfy this second factor, the relationship between the goods or services of the parties, it is not necessary that the goods and services be inherently similar, but rather that the general public would likely assume that the origin of the goods or services is the same. Now,
counsel, on that point, is there evidence in the record of other pet food companies that offer exercise classes? Or is there evidence of groups that offer exercise classes that also offer pet food?
Your Honor, we do not have specific evidence of this in the record, but the evidence that we do have is that the defendant has taken multiple actions to cement in the minds of consumers that it would be possible for him to also be producing dog food. Now,
right. But if you're talking about his actions and his state of mind and things he did to create a connection, does that really go to the relationship? Because as you said, isn't the question on the goods being related, would consumers tend to think that the same company would be offering pet food and exercise classes?
Well, Your Honor, thankfully, we actually have ample evidence of actual customer confusion in this case. So that does lead us to—
I understand that, counsel, but what I think is happening here is, as I ask a question about the one factor, you're telling me about other factors. And I just want to nail down on this factor about the relatedness of the goods and services. So if we could just stick to that one, and I'm happy to hear about the other stuff. But on that factor, what evidence do we have?
The evidence that we have for this factor is that the defendant maintained a blog through his company website, which listed many healthy food recipes for humans and dogs, where he actually even extolled Norm brand pet food and the many canine health benefits it had. He also talked about how much his own dog, Bingo, loved Norm pet food. So this really helped to cement in the minds of consumers that potentially the defendant himself was producing this dog food since he was advertising it on his own company blog.
Well, I think, counsel, that I would disagree that you can lump those together in terms of quantity. I believe there was a single reference on his blog to the fact that his dog had eaten Norm dog food. And by promoting recipes that you can feed to humans and dogs, isn't that an anti-pet food? I mean, isn't that not saying that there should be a separate pet food? Just give your dog what you eat?
Your Honor, the premise of Miss Ye's product, Norm brand pet food, is that it is an incredibly healthy, organic option for your pets. So just the mere fact that the defendant was passing out recipes for healthy dog food does not serve to separate Miss Ye's product from the defendant's exercise classes in the minds of consumers, but rather would help to connect them, because the entire premise of Miss Ye's business is that the majority of dog foods on the market do not serve pet health and wellness. And her product serves a niche market which wants to feed their dogs the most optimal and healthy dog food possible. So by passing out healthy recipes both on his blog and at the end of classes, as well as talking about how much he loves feeding his dog Norm brand dog food because of its numerous health benefits, the defendant was actually playing in to what the entire appeal of Miss Ye's product is, which is that our dogs should be eating as healthily as we do as residents of Utopia. And that
actually, counsel, that brings me to another point. What if I was inclined to say that the district court was precipitous in saying that the marks create the same commercial impression because your client created an acronym? I mean, Norm doesn't refer, she had no idea of using a connotation of either the man's name Norman or the word as a shortened form of normal. I mean, she was using it for her own natural, organic meat meals. And that was actually her company name. So didn't she create a connotation for her mark, which is dissimilar to the other side's?
Your Honor, while Miss Ye's mark is an acronym, Miss Ye and the defendant's marks are still similar. The district court correctly acknowledged that the marks are similar in appearance, with Miss Ye's mark Norm being wholly incorporated into the defendant's mark, the new Norm. And it's important to note that on all of Miss Ye's products, while Norm is in fact an acronym, her products do not list out the acronym itself, but in large font next to the logo of the black dog, it says NORMM. Now,
counsel, I have a question. Isn't it true that the new norm is based on the phrase or slogan used in Utopia in connection with the pandemic? And why doesn't that affect how people perceive the connectedness of the party's goods?
Your Honor, as you point out, the new norm has truly become a ubiquitous phrase in our new pandemic reality. However, in a case from the Federal Circuit, Shen Manufacturing Company versus Ritz Hotel Limited, the court established that when evaluating two marks under the similarity of the marks factor, the important question is not whether or not there are extra words, as there are in the defendant's mark, the new, but what words form the most relevant part of the mark? Here, Your Honor, the most relevant part of the defendant's mark is in fact norm. This
Counsel?
Yes, Your Honor.
As my colleagues, Judge Dunn and Judge Winter, are trying to tease out from their questions, why was this decided by the judge in the first instance on summary judgment? Shouldn't this, because of the different viewpoints of what the marks mean to consumers, have been decided at a trial?
Your Honor, this was decided on summary judgment because the likelihood of confusion is in sum a balancing test, as the defendant pointed out. And here there truly is no issue of material fact as to whether or not the parties' trade channels are substantially similar. Because
Yeah, my question though was on the marks.
Yes, so the marks were decided in summary judgment to in fact be neutral. The district court ruled that this factor did not weigh in favor of Ms. Ye nor in favor of the defendant. However, what we are arguing is that there is actually ample evidence that these marks in fact are similar. There's truly no issue of material fact here that this would need to go to the trial. Both marks contain norm. There's similarity in fonts, similarity in pronunciation. The addition of the second M in Ms. Ye's mark does not change the pronunciation whatsoever. As Shen Manufacturing Company established, as well as the case Lucky's Detroit LLC versus Double L Inc. from the Sixth Circuit, the addition of extra words in the marks, the two marks in question in that case were Lucky's Pub and Grill and Lucky's Steakhouse, does not disqualify the marks from being similar, especially if both marks operate in a similar geographic area. Here, Ms. Ye and the defendant operated their brick and mortar locations down the street, incredibly close in geographic proximity. And additionally, though the defendant stated that the mark of the defendant, of Mr. Herman, is a photograph of him and his dog, the true mark is actually a cartoon black paw print image, which is found in his photogram logo. And as they pointed out, Miss Ye's mark is a black cartoon dog. So the black cartoon dog and the black paw print image further connect these two marks in the minds of consumers. Additionally, as Progressive Distribution Services, Inc. versus United Parcel Service, Inc., a case from the Sixth Circuit pointed out, when we're evaluating whether or not two marks are similar, we should not compare the marks side by side, but instead evaluate them as they would appear to the public in usual marketplace settings. Your Honor, here, when these two marks are presented to consumers organically, consumers will likely confuse these two marks because they are so similar. Similar spellings, similar pronunciation, similar products and services. They are both.
Excuse me, counsel, could you review that similar spelling part? Because
yes.
It seems to me that when you have a four-letter word, that isn't misspelled all that often. And so you do have impact in increasing by 25% your mark. I mean, her mark isn't N-O-R-M, it's N-O-R-M-M. And so that has an impact. So they are not spelled identically. And I would say that adding that M takes it away from the dictionary definition of norm and the connotation of either the name or the saying, which is arisen in the pandemic. So again, the comparison of the spelling?
Your Honor, what this factor measures is not whether or not consumers can spell a name's mark from memory. Instead, what it measures, as was established in the Progressive case I mentioned earlier, is whether consumers who have only a vague or hazy recollection of the marks would likely become confused between the two marks because of their similarities. We simply cannot expect the average consumer to be able to spell a mark from memory, especially when a mark like Miss Ye's incorporates a unique spelling. So the fact that the second M does not change the pronunciation between norm and norm whatsoever means that even though the spellings differ slightly, this factor still should weigh in Miss Ye's favor. I'd like to just quickly review the 3 factors that the district court found did weigh in Ms. Ye's favor. The first factor is that the parties' trade channels are substantially similar. Here, both the defendant and Ms. Ye operate in similar geographic areas and advertise on the same social media channels. The next factor is whether or not Ms. Ye's mark is strong. Ms. Ye's mark meets all 4 sub-factors for this. Most importantly, her mark is incontestable because it has been registered with the USPTO for 5 years, and she registered her mark with the USPTO.
Counsel,
If I could ask you about that, about the strength of the mark, though, it is an acronym for a phrase that seems to directly describe her product. Isn't that correct?
Yes, it is an acronym. I'm not quite sure what you're asking, Your Honor.
What I'm asking is, what does the acronym stand for? And if what the acronym stands for is weak or descriptive, then don't we treat the acronym as also being, weak and descriptive?
So the district court found that this mark was overall distinctive in measuring its strength of the mark for this factor, and that is because it has been ruled incontestable by the USPTO for 5 years. As you point out, this is an acronym, Natural and Organic Real Meat Meals, but the fact that this is an acronym, coupled with the fact that there are no third-party registrations whatsoever, either from the defendant or from other third parties.
But counsel,
Yes.
the consumers don't know that the mark has become incontestable at the trademark office. Why is that? Why does that show that the mark is strong? I thought the strength of the mark has to do with consumer perception.
You are correct that consumer perception is one of the sub-factors for whether or not there's strength of the mark. But the most important sub-factor is whether or not the mark is incontestable under USPTO guidelines. And Your Honor, I am out of time, but may I conclude?
Yes, state a conclusion.
Yes.
Your Honor, because Ms. Ye and the defendant's marks are similar, because there is a relationship between Ms. Ye and the defendant's goods and services, because the parties' trade channels are substantially similar, because Ms. Ye's mark is strong, because there's actual customer confusion, because the defendant intended to derive benefit from Ms. Ye's mark, this court should find that there is a likelihood of confusion between Ms. Ye and the defendant's marks. For not only has there already been actual confusion, but all factors indicate that this confusion will only continue. Thank you.
May I proceed, Your Honor?
Yes.
Anton Kilkoff for the respondent, Ms. Ye. May it please the court. Next, Your Honor, summary judgment on the respondent's trademark infringement claim was proper for the following 2 reasons. First, the defendant willfully infringed on the plaintiff's trademark norm at the time that he adopted his nearly identical mark. And second, awarding the defendant's profits to the plaintiff was an equitable remedy for the infringement of the plaintiff's trademarks.
Counsel, on your first point, could you tick down for us the list of elements as to why you believe the infringement was willful?
Absolutely, Your Honor. As set out in Fendi, the factors supporting a finding of willfulness are 1, that the defendant was actually aware of the infringing activity, or 2, that the defendant's actions were the result of a reckless disregard for or willful blindness towards the plaintiff's trademark. What facts in
the record support either of those theories?
Absolutely. As to the first factor, the defendant was actually aware of the fact that he was infringing on the plaintiff's mark before and after adopting it. First, the defendant had actual knowledge at the time that he created his brand because he fed his dog Norm brand dog food, and because he admitted that he liked the brand because it was, quote, easy to remember because his name was Norm. Accordingly, at the time the defendant created the new norm, he had actual knowledge of and appreciation for the connection between the new norm and Norm brand dog food. Similarly, the defendant had
Excuse me,
actual.
but counsel, he was going into a completely different field. I mean, he was feeding his dog food, but he wanted to open a fitness studio.
Your
I
Honor,
mean,
it's
how
our-
is that? I mean, that seems to be assuming a trademark expert's knowledge of what infringement means.
Your
I mean,
Honor,
isn't he a 27-year-old former pizza deliverer?
That's true, Your Honor, but it's our contention that these aren't so dissimilar fields. While the defendant wanted to open this fitness studio, the core crux of that studio was his dog, and he talked about Norm Brand dog food and ran this blog. Without the dog, it's just a gym. And so the connection between the dog food and the gym is that pet-centered ideology, and that is why there was infringement, because the defendant appreciated that connection when he chose his mark.
Hold on, counsel. I do not understand what part of the record you're referring to when you say that it was a dog-centered fitness business. I understand that he advertised it by showing a picture of his dog and that the dog was mentioned on the blog, but I did not understand that it was dog. Well, again, if you'll cite that part of the record.
Yes, Your Honor. We'd be happy to submit a supplemental brief with the facts that the defendant's studio was for both humans and dogs to work out at. And that, in our mind, in our contention, we argue, makes this gym for both humans and dogs. And that connection is where the appreciation for that connection is why the actual knowledge existed. In addition, the defendant had actual knowledge because his customers expressed their confusion with the company's affiliation between Norm Brand Pet Food and the new Norm. On multiple occasions, the defendant was made aware of customer confusion caused by the similarity between the two marks. And instead of remedying that issue, the defendant continued to advertise Norm Brand Pet Food on his website, showing a blatant disregard for the plaintiff's rights. Finally, the defendant had actual knowledge because he received a cease and desist letter from the plaintiff. This letter specifically explained that the defendant's use of his mark directly infringed on the plaintiff's trademark and was directly causing customer confusion. In response, the defendant ignored the letter because he, quote, didn't want to waste his time and energy on negativity.
Counsel, when you say he just ignored it because he didn't want to waste time, what if he just disagreed with it? I mean, doesn't he have a right as an individual trying to run a small business to, look at that letter and evaluate it himself? And if he doesn't think it's a problem, then how do you impute that he did think it was a problem? I mean, it's about his intent, right?
Absolutely, Your Honor. But
mistaken, but you might disagree with him, but that doesn't get to the fact that he had a bad intent.
So specifically for this factor, that he had actual knowledge of the infringement, we're saying that the cease and desist letter put him on notice of the possible infringement and that he was aware of that. But your question gets directly to the second factor, which is willful blindness. In the alternative, Island Software held that a defendant's actions are willful if they're a result of a reckless disregard for or willful blindness towards the plaintiff's trademark. As established in both Yermian and BBK, a defendant is willfully blind when they know they might be selling infringing goods, but nevertheless intentionally shielded themselves from discovering that truth.
Excuse me, counsel, but your client. I'm sorry.
What in the record shows that he was he knew that he would be infringing? I mean, he did an internet search and he talked to his friends. I don't recall any evidence that he knew beforehand, as opposed to after receiving the cease and desist letter, that he had a clue about what even infringement was.
Yes, Your Honor.
Why doesn't that matter?
Yes, Your Honor. So it's our contention that beforehand he saw the connection and appreciated the connection between the new Norm's dog food and the connection to his name. And we're saying that knowledge, he used that knowledge to create his brand and advertise it in a way that connected to norm brand dog food. So it's our contention that that was the knowledge before he created the new norm. And as to the knowledge after, the cease and desist letter specifically spelled it out. The plaintiff's cease and desist letter told the defendant that he was infringing on the plaintiff's mark and that he was causing customer confusion. That is direct knowledge and direct evidence in the record. And additionally, the fact that the defendant only ignored one cease and desist letter is immaterial. As explained in both Microsoft and Fendi, courts have
Counsel?
repeated.
On the issue of disgorgement, what about the fact in the record that there was no proof that plaintiff lost any actual sales due to the defendant's activities?
Yes, Your Honor, that gets to the difference between disgorging the profits because the plaintiff lost sales versus because the defendant was unjustly enriched. You see here, the trademark is the center of the show, and and it's the defendant's actions that we're evaluating. And the fact of the matter is, the defendant was unjustly enriched.
All right, so
Now, hold on that. I'm sorry.
go ahead.
Thank you. So counsel, he didn't offer fitness programs. He was enriched because all of the business that came to him was due to the dog food being sold down the street. Nobody came and gave him money to participate in the fitness classes. That's your premise? All of the success of his business is attributable to your client selling dog food down the street.
Your Honor, it's our contention that he used Ms. Ye's mark to get customers through the door. And that is an improper use of a trademark. As trademarks can be viewed as a form of property, and as established by the court in Meyer Brewing, a trademark infringer is unjustly enriched if he's allowed to keep the profits off the misappropriation at all of the plaintiff's property. And that is what the defendant did here. He willfully chose to use the goodwill built up by the plaintiff in the dog health and wellness space through years of positive customer interactions to secure those additional customers and sales that he otherwise would not have received. In addition to preventing the unjust enrichment, Four Pillars also says that a disgorgement of all the profits is necessary to deter willful infringement, both by the defendant and other market participants in general.
Counsel, if I could ask a question on that. The $3 million was absolutely every bit of profit he had earned from the beginning of this business. Are you saying that anything less than that would not deter, would not send a message? What if the court had ordered, 50,000 or, 500,000 or something for a small business? Even those would be burdensome, I assume.
Yes, Your Honor, but it wouldn't be burdensome enough. The problem with not awarding all of the profits as damages is it turns it into a cost and benefit analysis. And this court should not make misappropriation of property an economic decision based on a cost benefit analysis. If the court allows...
But we don't have evidence. You emphasized earlier the cease and desist letter. Well, that comes well into the storyline, right? So, I could see you might argue that from that point forward, the profits might be unjustly earned. But what argument do you have for disgorging the profits from prior to that point?
Yes, Your Honor, it's still it's still our contention that the defendant knew at the time that he created his mark the connection between the new norm and norm brand dog food and used that connection to his benefit, which is still a misappropriation of property and still falls within the time frame that the defendant's profits should be disgorged to Ms. Ye.
Well, then to follow up on Judge Thurman's question, if it was unfair before the cease and desist letter, was it unfair before he heard a customer say, "Oh, you should sell the dog food right here in the studio"?
Yes,
if he had no idea of actual confusion, what was the injustice before that?
Your Honor, we're not conceding that there wasn't any confusion before then. When the customers complained, that was already evidence that it was happening, but it doesn't mean that that confusion wasn't occurring before. And it's our contention that the defendant knew of the connection at the time that he created his mark. And that's the fact that cements that all of his profits came from a misappropriation of Miss Ye's property. And that's why a disgorgement of the entire $3 million is necessary.
So counsel, it sounds like your misappropriation argument is essentially a strict liability argument here. I mean, it doesn't sound like you're bringing intent into that. You're saying if he misappropriated it, if it's just found later that he made a bad decision and misappropriated somebody else's goodwill, then we should disgorge all the profits. I don't read the cases that way, even Romag. What's your argument for that?
Your Honor, we're not arguing that it is a strict liability. We still have to prove that the defendant was either willfully blind or reckless, and we're contending that that's what the defendant was willfully blind, and that the defendant had actual knowledge of his infringing activity before and after he created his mark. After that is satisfied, the question is just how much needs to be taken away and disgorged, and that answer is $3 million, both to get rid of the unjust enrichment as well as to deter further willful infringement, both by the defendant and other market participants in general. You see, if this, in addition to the fact that, you know, you could give 50,000, you could give less, if the court allows the defendant to keep any of the $3 million that he received, it signals to the market that anyone can willfully infringe and possibly make money depending on the court. Thus, the court should disgorge all of the profits made by the defendant, both to deter the defendant himself and other market participants. Infringement just isn't a business decision. In the end, Your Honor, this isn't a defendant looking to avoid time and energy on negativity. This is a defendant looking to avoid time and energy on honest work. For the foregoing reasons, we ask this court to uphold the decision of the district court and tell this defendant that he does not get a free ride. Thank you.
Counsel for appellant, do you have your rebuttal?
Yes, Your Honor. Opposing counsel today made a number of arguments that are unsupported by the record. There's no evidence that any pet food companies in the world offer exercise classes. That's not a reasonable assumption, and it's a stretch to take it so far here as to say the general public would make it. Ms. Yee is not entitled to blanket ownership of the entire commercial space for any business that has anything to do with dogs. There's also no evidence in the record that the goodwill Norm Dog Food had, and we recognize the customers love it, but there's no support for opposing counsel's assertion that it contributed to a single sale that Norm made at his fitness business. The lower court should not have held Norm liable on summary judgment for deliberately and intentionally causing confusion when the record does not establish intent beyond dispute. Awarding every cent of my client's profits would not discourage infringement, it would discourage business. Thank you.
Thank you. I believe, Bailiff, I believe you're muted.
Sorry. The judges will now retire briefly to deliberate. Please remain in the courtroom and the judges will return shortly to critique the arguments. very deliberate. And they put you into another conference room.
It's okay. So they're just switching.
Oh, okay, but they haven't done the receipt yet.
Okay.
So I know the INTA people, they know what they're doing, I guess.
Okay.
We're back.
We're back.
Juliana.
Where is our bailiff?
She just stepped away. She should be back. I don't know if she's paying attention to the screen.
Good work, teams. I think we can say that without the bailiff.
Yeah, we can go ahead and start a little bit of discussion here. We don't want to delay things going forward here.
Yes, please go ahead.
We were, I will say that the panel was barely ready to return to the room here. And that's because we found this to be an extremely close round. We thought all of you did a fantastic job. It was very, very close. I believe that we find, or well, I don't believe, we do find here a very, very narrow margin for appellant over the appellee in this round. And I'll let this go to the other members of the panel to go ahead and start offering some specific comments and thoughts.
I guess I could start. I'm sorry, Ms. Hunter, if I have her name correctly. Yes, I'm sorry. Well, I like that you started off with the problems with the genuine disputes as to material fact. That was not something that was discussed very much in the materials, and I'm glad that you pulled that out. You also were not thrown by Judge Udis's questions, and you kept to the, I don't want to say you kept to your script, because you didn't sound, like an automaton, not at all. You were you had something to say, and you kept to that, and I think you did an excellent job. I think that some of the other judges had another comment about some substance about your what you presented, and I'll let someone else go forward on that.
I think you're muted, Ms. Hunter.
Thank you, Judge Winter. I appreciate it.
Yeah, I'll mention just very briefly on the kind of substantive points, and this is something very generally for all of you. You don't have that much time in an argument, and you obviously you're trying to do two things. You want to hit your strongest points, so don't start on your weakest points and the things where it's the longest shot that you're going to change what the district court said. You probably don't want to start with those, because you might not get much in at all before you get questions. When you do get questions, of course, you want to address whatever those are, because that shows where the judges are concerned. So all of you at one point or another tried to kind of get out of a question or a line of questioning to kind of go back to something you were a little bit more comfortable arguing about. Be very careful doing that, because when the judges ask questions, that you need to spend enough time there. I don't know that we want to go into too much detail on specific substance, but I would just say look at the likelihood of confusion factors for those of you who are handling that part of the argument pretty carefully. And the parts that help you, that's really where you probably want to emphasize. If you're getting aggressive and trying to argue that you clearly should win on the points that you lost on already, that you got to realize you lost on those for a reason. They're not probably very strong for you at the most. So anyway, that's just some thoughts on kind of substance. But I want to let the other judges make some comments on the arguments. Judge Dunn, I think you're muted.
Did you want to go next, Jonathan, or did you want to bat cleanup?
I'll back cleanup. Go ahead.
Okay. So I thought you all did a very good job in swiveling back to your main point. That we put in questions, they weren't always directly related to what you were talking about at the time, and you all answered the question, sometimes not as directly as we would like, which is endemic to appellate argument. But you did all, know what you were there to do and go back to it. I would agree that in terms of time management, likelihood of confusion, I would have liked to have seen moving a little quickly from one to another, as opposed to getting bogged down on one or two. You want to be nimble. What's kind of fun about likelihood of confusion is that there are so many factors, and these problems always have a little something for everybody. I reiterate what Judge Thurman said, which is I would lead with what the district court liked. All other things being equal, the appellate court will probably like what the district court liked, and if it's in your favor, of course, start with that, stay with that. In terms of demeanor, you all, of course, were very professional. Nobody raced too quickly. I think going last, maybe you were sitting there getting worked up, listening to everybody else, but I think it almost got a little bit too aggressive at the end. And really the whole, disgorge everything for any reason was a little over the top. If it hadn't been the last minute, I would have cut in. But you are being hired to represent, and represent you did. I think you were all pretty comfortable with the burden of proof, and that's always good to see. And I also think you did have, you all did know what your best arguments were, which is important. As I said, you went back to them. I would have liked to have seen maybe a little less to try and cover everything that was there. But I guess my most significant criticism would be the time management, but overall, I was very favorably impressed with the way you were able to handle the demeanor, the amount of work going through, handle the questions that were designed to throw you off to return to your point. And that would be it for me. Thank you.
Okay, so I'll do the cleanup. So, Ms. Charles, you started very strong, and the problem was there were points where the judges asked you to concede parts of the ruling below in the record. You were really hesitant to do that. Also, when the chief judge tells you it's time to wrap up, you've got one sentence, not your fully prepared remarks. In real life, that bothers the appellate panel. Mr. Kyloff, I liked you came out really strong. I like the way you organized your argument. What I would say is keep your hands down. None of this and this and this. Just keep your hands down like you're doing right now and don't move them from the lectern. Also, when Judge Thurman was hammering you on the standard of liability, whether you were almost going strict liability, you almost got yourself hung up on that. Be careful. But otherwise, I thought you were really strong. Mr. Katzman, I thought you were really good, but when the judges peppered you with questions, you started getting a little evasive. So when a judge asks a question, answer the question and move on. But don't just move on to what your favorite argument is. Overall, I agree with Judge Thurman. The four of you were really strong, professional, and you did all a great job. That's all I've got.
Okay.
Thank you.
Yeah. So are we?
Bailiff, is it okay for us to go back to our room?
Yes, I'm gonna put you guys back in the breakout. I'm gonna put you guys back in the breakout room, and the other students have to get to the other courtrooms. And so we're running a little behind, so we're gonna wait for everybody to get to the designated courtrooms. So
Right.
judges are gonna put you in the breakout rooms.
Okay.
Okay.
Great.
Thank
Thank you.
Good luck,
Great
guys.
job, all of you.
Thank you.
Very good.
Okay.
Probably
No.
won't start the second round till 2.
Till 2-ish? Okay, they just said behind and just go to the second room. That's the only message we got.
Okay.
So I'm just gonna eat my lunch.
Okay, good.
We start the um So I have the New York team 65 and Dallas 37. Let's see. Welcome, I'm Juliana, your bailiff. If I can have the appellant, are you going to be reserving any rebuttal time?
Actually, we're all Dallas 37.
Okay.
Yeah, I was just gonna tell you, no one for New York showed up as yet. Well, one was on, but he dropped off, so I'm just waiting.
Okay. Well, if you want to tell me, I can just write down your times, how you'll be splitting it, speaker 1 and speaker 2.
Yes, it will be 15 minutes apiece, please.
Perfect. That's easy. Great. Thank you.
Sarah and Charles are students as well? I don't
There
have
are
a list.
coaches.
Oh, coaches. Okay.
There's just the two of us.
Okay. Okay. So there's a Wells not joining.
No, she's an advisor.
Okay.
I don't know if she will be joining.
Okay. So just waiting for New York. Okay. Thank you so much. Hi, everyone can hear me? The other team is still in their courtroom, so they're gonna be here shortly. Sorry, we apologize for the delay. They were delayed in the courtroom, so they're coming.
Thank you.
Hi, so Matthew, Jacob is here.
Yes, hello.
And who's the other? All your team members are here now?
We're just waiting on Nigel Bryant, and he should be coming in momentarily.
Okay, thank you so much. I think we're all here now, so we're ready, bailiff?
Okay, so for the appellant team, would you like to tell me how you're going to divide your time?
Sure. Sorry.
We're taking 14 minutes and 30 seconds for each of us. 30 seconds off each of our times.
And then is that 1 minute you're just keeping for rebuttal?
Yes, sorry, 1 minute for rebuttal.
And I think you did this in earlier, so you'll be able to see that. And I'm ready. So I think, yeah, we can bring the judges in.
Okay, so I'll bring them over now.
Great.
Hi, Juliana.
Hello again. Hope you had a little bit of a break. Okay, it looks like everybody's here.
Yes.
Okay, great. All right, here we go. Hear ye, all persons having business with the United States Court of Appeals for the circuit draw near. Give your attention and you shall be heard. The court is now in session. The Honorable Mark Thurman, Elizabeth Dunn, Jonathan Nudis, and Elizabeth Winter presiding. Norman Herman Enterprises, LLC DBA, the new norm versus Natural and Organic Real Meat Meals, LLC. Is team NY65 for the new norm ready?
Yes. Yes.
Is team Dal 37 for Natural and Organic Real Meat Meals ready?
Yes.
Yes.
All parties ready, your honors. Counsel, there are 3 issues on appeal raised by the plaintiff. For purpose of our arguments today, the defendant will be deemed the appellant because the court granted Natural and Organic Real Meat Meals motion for summary judgment and awarded it $3 million. The appellant will argue first in each round and may reserve up to 5 minutes of its time for rebuttal. The plaintiff, Natural and Organic, is the appellee. Our rules do not allow for rebuttal arguments by plaintiff, appellee, Natural and Organic. Each party will have 30 minutes to argue. Counsel for the new norm may reserve up to 5 minutes for rebuttal. The bailiff, I will hold up time cards 5, 3, 1, and 0 when there are 5 minutes remaining, 3 minutes remaining, 1 minute remaining, and when time is up for each participant. During rebuttal, if any, the same timekeeping procedure will be applied. The new norm, will you be reserving time for rebuttal?
Yes. We'll be requesting 1 minute on rebuttal, taking 30 seconds off each of our times.
Okay, how will you divide your remaining time? That'll be?
Sorry, 14 minutes and 30 seconds for each of us.
Perfect. Natural and Organic, how will you divide your time?
15 minutes apiece, please.
Okay, counsel for appellant, you may begin.
Thank you. Good afternoon or good morning, your honors, and may it please the court. My name is Nigel Pura Bryant, and together with my co-counsel, Matthew Jacobs, we represent the appellant Norman Herman III. I will be addressing the likelihood of confusion issue, and my co-counsel will be addressing the willful infringement and damages issues. We will be requesting 1 minute on rebuttal, taking 30 seconds off each of our time. Would your honors like a brief recitation of the facts?
As you please.
A former delivery person created a business using a creative mark, the new norm, that reflects his name and nature of his business, and the respondent, owner of Norm, alleged trademark infringement claims. This case is about ensuring that trademark law does not prevent small businesses from succeeding in the marketplace by failing to properly analyze claims in a factual matter. This court should reverse the lower court's decision for the following 2 reasons. First, the district court failed to properly balance the relevant factors in a consumer confusion analysis. And second, the district court failed to include pertinent factors in the consumer confusion analysis, which strongly support a lack of confusion. This case is being reviewed de novo, and to my first point, the relationship between the respective goods and services are so different that there is no likelihood that Norm's consumers will believe they are purchasing dog food when they're signing up for the new Norm exercise services.
Counsel, what about the fact that your client not only offers exercise classes, but recipes, and in the exercise classes, the dogs can come with the owners, and the recipes include dog recipes. How is that different goods and services?
I'm sorry, Your Honor, the audio is a little low. Can you repeat the question? I'm so sorry.
All right. Can you hear me now?
Yeah, a little better. Thank you.
Okay. So we have dog food for the plaintiff, and for the defendant, he offered exercise classes where the dogs could come with the owners, and he also offered recipes, including not only human recipes but dog food recipes. How is it then that the goods and services are so different as you're claiming?
Your Honor, they're so different because the primary purpose of Ms. Yee's mark and business is for pet foods, and the primary purpose of Mr. Herman's services are for exercise, directed towards people. And you're correct in the consideration that Mr. Herman did market towards individuals with pets, but it's not a requirement to participate in his exercise services to have a pet. That's not a requirement to participate.
What about the recipes?
And addressing the recipes, Your Honor, yes, it is true that he advertised that on his blog, but that wasn't the primary point of his business. And there is still a distinction, the distinction between the pet food and exercise services, which is what this court should focus on. And even though both the goods and services are related to pet health, when a consumer is shopping for dog food, there's no likelihood that they will mistakenly sign up for an exercise regimen, Your Honors. And according to the Second Circuit 2020 case, Saxon's Glass versus Apple Inc., the court held that the distinction between services and products was enough to sufficiently differentiate the areas of commerce, favoring no likelihood of confusion. In that case, Your Honors, Saxon sued Apple for using the term Ion X to describe the Apple Watch. And the court there held that because the products were not proximate with each other, because Saxon offered glass strengthening services, whereas Apple sold products directly to consumers. And
then could you, counsel, address the possibility that plaintiff would go into a natural zone of expansion into either dog recipes or dog-related exercise?
Sure, Your Honor. And I think that speaks to, I guess, the likelihood of the respondent to bridge the gap, which is a factor that the lower court didn't consider altogether, which is a part of my second point, which also favors unlikelihood of confusion. And according to the Second Circuit 1961 perennial case, Polaroid versus Polaroid Effects, the likelihood to bridge the gap and sophistication of buyers could shed light to consumer confusion. According to the 2004 Southern District of New York case, Strange Music versus Strange Music, Inc., in order to bridge the gap, the respondent was required to show that two things. One, she intended to enter Mr. Herman's market, and two, that prospective consumers were aware of this intention. However, the record does not show that the respondent had any intention to enter Mr. Herman's market, nor did the record show that prospective consumers were aware of this intention. And Your Honor, that's a relevant consideration for this court. And that consideration alone is enough for this court to remand for a fact finder to determine this inquiry. Back to my first point, not only addressing respective goods and services, but the similarity between the marks, another factor pertinent for the consumer confusion analysis. To assess similarity between the marks, we look to sight, sound, meaning, and context. And taken in totality, it suggests no likelihood of confusion. As to sight, we're concerned with the mark as a whole. Mr. Herman's mark, the new norm, contains 2 additional words and is missing a letter. And according to the Fourth Circuit 2014 case, Grayson O. Co. versus Agadir International LLC, 2 marks are sufficiently different when the alleged infringer's mark was missing a similar letter and had 3 additional words. Similarly here, Your Honor, that court held that there was the only textual similarity between the marks was 1 portion, and the only textual similarity between our marks at issue is the 4 letters NORM.
Excuse me, counsel, but does not your client treat the norm with 2 M's and the norm which he uses to refer to himself as the same thing? I mean, doesn't he make a joke in conversations with his dog about here's Norm with your norm? I mean, but your position is now that they create different commercial impressions?
Yes, Your Honor, that's exactly our point. And for the purposes of trademark law, we're concerned with consumer confusion, and the similarity, though it may exist, it's not substantial enough to establish similarity of the marks weighing in favor of the respondent, Ms. Yee.
But counsel, if I could follow up, I mean, in addition to the similarity between the terms norm and norm in the 2 marks, the nature of the difference between the marks, doesn't it actually reinforce the common term? When you say the new norm, are you not referring to norm? I mean, this isn't an addition which changes the commercial impression, is it?
Your Honor, the new norm mark has a dual nature. One describes the nature of his business, which is a transformative exercise service, and so the new norm suggests the new version of norm after utilizing his exercise service. So it does make a commercial impression, and viewing the mark as a whole, they are substantially different, establishing similarity between the marks in favor of Mr. Herman.
Well, excuse me, counsel, and I will let you move on in just a minute, but I would say that may be your client's intent, that they know it's the new norm, but the person who was selling dog food was there first. So if someone's familiar with norm and they see the new norm, how are they to know that it refers to your transformative client?
Your Honor, that is an issue, and that is a direct issue of fact that we're concerned with. The record doesn't establish whether or not consumers are aware, it doesn't establish the way consumers interact with the mark. And that establishes the meaning sub-factor for analysis for similarity between the marks. Furthermore, Your Honors, this court should remand this case to determine what the dominant portion of the trademark is. According to the 4th edition, Kalman on Unfair Competition, Trademarks and Monopolies, Section 2118, the dominant feature of a trademark is whatever is most noticeable in actual conditions. And the record does not indicate which part of the mark is most notable in actual conditions. This fact is material because according to the 4th Circuit 1995 case, Lone Star Steakhouse and Saloon Inc. versus Alpha, Virginia, courts give the dominant portion of the mark more weight when assessing similarity because consumers are more likely to confuse marks with dominant similar features.
Counsel, in that respect, what is your position of what is the dominant element of your client's mark?
Your Honor, it certainly may be norm, but that is a genuine issue of fact. That isn't appropriate to be decided on summary judgment. A fact finder, like a jury, should be deciding that fact.
All right. So if you're conceding that norm in your client's mark is the dominant element, with the new not being as source identifying, then you're comparing it to norm, N-O-R-M-M, which spoken sounds identical to the dominant element of your client's mark. So it's the new normal, or excuse me, the new norm versus norm. And why aren't those marks similar to one another?
Your Honor, they're not similar as a matter of trademark law because we need to analyze sight, sound, meaning, and context. So though the dominant portion of the mark may be norm, and I don't mean to concede that we believe that it certainly is the dominant portion, we do believe that this court should view Mr. Herman's mark as a whole, the new norm. Sound alone isn't enough to weigh in favor of the respondent.
But it is enough to find that the marks are similar, isn't that right?
No, Your Honor, not by itself. You have to take that factor, sound, in totality with sight, meaning, and context. Furthermore, Your Honor, the lower court failed to consider the sophistication of buyers. And consumers of the exercise services are committed to the purchases they make. It's not that they purchase the product and don't think about it. They purchase the service, then have to follow through and conduct the exercises. This is not an impulse purchase, Your Honors. Additionally,
Counsel, can you point me to where in the record there's evidence to show that it's not an impulse purchase, that it's a seriously considered purchase to start a fitness class?
Your Honor, there isn't explicit evidence to the record to that effect, but presumably those that purchase exercise services that want to transform their life will be committed to following through with the exercise. And if that is a contentious issue of fact, then this court should remand for a fact finder to determine that, Your Honors. Also, as a matter of public policy, we want to encourage people to create small businesses and protect those that use their name to describe their business. We want to see the whole picture and give the court the most information to make an informed decision. The lower court improperly analyzed the likelihood of confusion factors, as this court should reverse as a matter of law. If these factors are deemed contentious, it should be remanded for a fact finder to find and to analyze under the appropriate test. For those reasons, Your Honor, we ask this court to reverse and remand. Thank you.
Good afternoon, Your Honors. May it please the court. My name is Matthew Jacobs, and I will be arguing the willful infringement and damages issues on behalf of appellant Mr. Herman today. This case is about ensuring that small business owners are encouraged to enter the free market economy without fear that courts might summarily seize their hard-earned profits. This court should reverse the district court's grant of summary judgment to respondent for the following reasons. First, the district court's willfulness analysis failed to construe the evidence in the light most favorable to Mr. Herman, as it was required to in deciding respondent's motion for summary judgment. And secondly, the district court's grant of the entirety of Mr. Herman's lifetime business profits was in direct conflict with the Lanham Act's explicit command that all remedies brought under its name comport to the principles of equity, and was thus an abuse of discretion.
Counsel?
Yes, Your Honor.
Yeah, what about the fact that your client adopted his mark without consulting trademark counsel, did experience communication suggesting actual confusion, and kept going with his business even after receiving a cease and desist letter? Why are those not factors that would contribute to a finding of willful infringement, then setting up the analysis for disgorgement of profit?
Your Honor, the reason that those facts in and of themselves independently, or even when taken together in totality, are not enough to establish willful infringement is because, as my co-counsel was discussing, we're at the summary judgment level, and not one single one of these facts, when construed in the light most favorable to Mr. Herman, leads to a finding of willfulness. And as the Second Circuit's 2019 decision in Four Pillar Dynasty versus New York and Company explained, there are two forms of conduct that can lead to a finding of willful infringement. A defendant has to act with either actual knowledge of their infringing activity or be willfully blind or recklessly disregard the same. And under either of those standards, Mr. Herman was not willfully infringing here.
What about the fact that he was aware of the plaintiff's mark and product, in fact, ordered it and served it to his dog before engaging in his venture?
Your Honor, prior knowledge of an existing user's mark is not equal to knowledge of infringing use. And for instance, as the Second Circuit held in their 1995 case, Arrow Fastener Co. versus Stanley Works, prior knowledge in and of itself does not lead to a necessary inference of bad faith or willfulness. And knowing infringement is that which is calculated with a certain level of intent to benefit off of the goodwill that a plaintiff has garnered in the market. And Mr. Herman did not act with any intent or calculation to benefit off of Miss Yee's dog food company when he started a personal fitness brand that was a direct reflection of himself and his own life experience. The record—
Counsel, I have a question. Excuse me.
Sure.
Don't you think that Norm should have known that he should have reasonably known that his trademark would be confusingly similar to the two appellees' Norm product, given that he talked about the Norm food, the pet food, in his blog?
Your Honor, while the record does indicate Mr. Herman, as you referenced, mentioned the pet food on his blog and had a background familiarity with the mark, and indeed, yes, concededly knew his personal first name was similar to the respondent's mark, that doesn't lead to the inference that he therefore intentionally sought to benefit from it, or should have known that consumers might be confused between a fitness company and a pet food company. And his good faith adoption of the mark was based on three distinct factors laid out in the record at page 8. He chose the new Norm name because it includes his own name, he's Norm. It made reference to a personal life story. This is a man who was inspired to start his business because he reinvented himself. He had a health scare, turned it into a unique fitness regime for himself. And then—
So if I could interject, I understand what you're talking about now, and your focus is on his adoption. I'm a little more concerned about whether at some point after he adopted it and was using it, did he at some point learn enough of what was happening that we should say it became willful infringement? So if let's say I agree with you that he was acting innocently and in good faith when he adopted the mark, over time he finds out that people are being confused by it. At some point he gets a cease and desist letter. Doesn't he at some point need to do something? I mean, doesn't he need to, doesn't that affect his intent at some point in time?
Your Honor, the cease and desist letter is an interesting question because the law is not clear on this. One that fails to to act upon receipt of a cease and desist letter as a matter of law is not necessarily acting willfully. As the Southern District of New York held in 1999 in Something Old, Something New versus QVC, a defendant's decision not to completely abandon their own business enterprise merely on receipt of a cease and desist letter, which we should remember is merely the opinion of an attorney and their client, does not lead to a willfulness presumption. And
right, but you know, as I was trying to point out, it's not just that he received a cease and desist letter out of the clear blue and nothing else ever happened. That's what I'm trying to get at. It seems like we have kind of a progression here where, you know, he's dealing with people who are confused, actually confused by the marks. He then gets a cease and desist letter. At some point, don't we have to hold him responsible for the consequences of continuing to use this trademark?
Your Honor, all of those elements that you just made reference to are ripe facts for jury adjudication. They are facts clearly in dispute, and they are not facts that on their face lead to the necessary conclusion that Mr. Herman willfully infringed, as the district court erroneously held by granting summary judgment on the willfulness issue. The fact that we could be having this discussion and we can, you know, reasonable minds can agree and disagree at various points along these different fact elements is exactly why this case shouldn't be here, and it should be before a jury right now. And in particular, although I understand Your Honor's point regarding the cease and desist is not in and of itself the only element here, that element is undercut by the fact that Mr. Herman had a good faith belief that there was not a reasonable likelihood of confusion because the phrase he was using was generic, which was the exact situation in Something Old, Something New, the SDNY case, where the court held that the fact that the phrase was generic in nature was enough to show that it was undertaken in good faith to not abandon at a cease and desist.
Counsel, are you arguing that in this case, norm is generic?
No, Your Honor, and thank you for asking that. Let me clarify. What we are merely arguing is that Mr. Herman believed the new norm, as the record at page 8 shows, was in ubiquitous, wide, generic usage in the Utopia area. And indeed,
what proof is there of that in the record?
The record at page 8, Your Honor, indicates that in selecting the name, Mr. Herman believed that he was selecting a name that was a catchy play on a then widely used generic phrase. And there's strong evidence that the phrase is rather, does not indicate a single source, as would be required to show that he was intending to indicate Ms. Yeast as the source of his business, in the fact that the phrase is ubiquitous in popular culture.
Well, excuse me, counsel. The phrase isn't the new norm. It's the new normal. So why should we think that people are going to associate the new norm with the new normal? They're not the same.
Your Honor's point is well taken. They're not identical. It is a variation. However, we strongly submit to Your Honors that these are really fact-intensive analyses, and they should go before a fact finder, not be decided by the stroke of one district court judge's pen on such a thin record. And to my second point, the award of Mr. Herman's every dollar of profit that Mr. Herman made in the 3 years from the time he began his business up till to today of $3 million cannot be construed as comporting with the principles of equity as the Lanham Act mandates. And the Lanham Act further mandates that any monetary damages are intended to compensate, not to penalize. But the record at page 10 here shows that Ms. Yee, respondent, doesn't believe that she's lost a single sale or profit. So there's nothing to compensate her for. And even so, the primary justifications for an award of profits, as Four Pillar Dynasty and other cases have held, are unjust enrichment, compensation for actual losses, or deterrence of a willful infringer. Now, we of course have to note that the Supreme Court in 2020 in Romag Fasteners versus Fossil explained that willfulness in and of itself is not a prerequisite. It's also not necessarily in and of itself sufficient for profit disgorgement. And so looking really to unjust enrichment, the closest thing to any version of unjust enrichment here that the record indicates is that Mr. Herman noted at page 11 that he, quote, God bless you, Your Honor, that he perhaps received one or a handful of clients as a result of them being confused. That's not $3 million worth of profit. And
excuse me, counsel.
Sure.
But what if her point is not that she lost business, but that his entire business was built on her good name? That this allegation of the new normal is the same as the new norm is unconvincing, and that what he just did is say, you know, norm is for pet food and the new norm is when you combine your pet food with exercise. And so she says the unjust enrichment is that he built his business on what she did.
Your Honor, our strongest counter to that argument is that Mr. Herman didn't act like somebody that was trying to trade off of another person's business association. He was hit front and center, a part of his brand. He is norm. He became the new norm. That's how he marketed himself. That's how he put himself out to the public. And whenever, as the record at page 9 and 11 show, whenever anyone, the small number of people who claimed to be slightly confused, whenever they approached him, he denied any connection with respondent's brand. That does not speak to somebody who's attempting to free ride the way that an argument in that line would suggest.
Well, counsel, I guess I would say that he told 3 people that he had no connection, but even though fitness classes don't rely on recipes as a general part of their marketing, he didn't take down the recipes. He had actual confusion, and his website, which spoke to the whole world rather than a couple of individuals, continued to make the explicit association between pet food and pet exercise.
Well, that may be, Your Honor. We can't stress enough that these are really fact determinations, not questions of law, and thus weren't suited for summary judgment. But even further, as a matter of public policy, for courts to, at the summary judgment level, without a showing that the alleged infringement led to a loss of profits, or to Your Honor Dunn's line of questioning, an explicit showing certainly doesn't exist in the record that Mr. Herman gained any profits. It would be we would have to take a leap and make a lot of assumptions and inferences to get there. Without either of those things, it was an incredible abuse of discretion for the district court to take away this man's entire lifetime profits. His blood, sweat, and tears as a small business owner, he built the American dream, and we shouldn't allow a district court sitting at the summary judgment level to take away that American dream. Thank you.
Thank you, counsel.
May it please the court. My name is Kelly Neal, and along with my co-counsel Matthew Griffith, we represent the appellee, Shaggy, owner of Norm. There are 3 issues before the court today. I will be addressing the first issue, that a likelihood of confusion has already occurred, and my co-counsel will address the second and the third issues, that Norman's actions were willful and disgorgement of profits was proper. This is a case about a businessman purposefully cutting corners by copying Shaggy's nationally known trademark so as to trick customers into thinking the brands are related and thus wrongfully gaining success in his new business. The district court correctly held that confusion between Norm and the new Norm has in fact already occurred and granted summary judgment in favor of Shaggy. This court should affirm that decision for 3 reasons. First, the undisputed evidence shows actual consumer confusion. Second, marks do not have to be competitive to support a finding of consumer confusion. And third, Shaggy's federally registered and nationally known mark is distinctive and strong. Your Honors, opposing counsel indicated that because consumers would not be confused as to purchasing dog food with exercise classes. That's not the correct analysis of a likelihood of confusion. Likelihood of confusion analysis looks at whether a reasonable consumer would be confused as to the source or origin of the goods and services. Whether there's an affiliation between the marks is the issue before us in this case. And that affiliation has been shown through actual confusion as indicated by pages 9, 10, and 11 of the record. And
Counsel, if I could interject, you started out talking about the relationship of the goods and services, and then it seems like you're jumping to actual confusion and saying the actual confusion shows that the goods and services are related. Can you tell me about any evidence that shows other parties that sell pet food also offer exercise classes, or the converse, that there are groups that have fitness classes that also sell pet food? Is there any evidence of that nature in the record?
Your Honor, there is not any evidence of that nature in the record. However, what we do have is a record before us that does show actual consumer confusion between two brands, and that Shaggy, the senior user, has a federally registered trademark for
Okay,
pet food.
I understand that part, but I'm just trying to narrow in. Is there evidence in the record on the question about whether the goods and services here, pet food versus fitness classes, are related in a material way?
Your Honor, the record does indicate that there is a relationship between the two goods and services because they both involve the same audience and the fact that they both involve pet health. Norman explicitly used Norm dog food when he was trying to get healthy and to get his dog Bingo healthy, as indicated on pages 8 and 9 of the record. And furthermore, Norm's fitness regime includes a healthy diet and exercise. And he, as indicated on pages 10 and 11 of the record, he's actually had actual customers come up to him and ask him why he was not also selling Norm dog food in conjunction with his fitness classes. And so he has made this affiliation known in the minds of his consumers. And that's what a likelihood of confusion analysis is whether or not there is confusion between the source or origin of the goods. And while the goods in and of themselves do not necessarily have to be related here, they are, because they both involve pet health.
Counsel, these findings from the record that you are relaying to us, shouldn't those facts be adjudicated by a fact finder after a full trial, rather than in the truncated manner that this judge did on summary judgment? Shouldn't we really have the full facts come out and see what comes of them at trial rather than on a summary judgment record?
Your Honor, that's not the case. A trial would not only speak to judicial inefficiency, but was not necessary in this case with the facts that we have here. Summary judgment, the standard for summary judgment is for discovery, when it comes to summary judgment, is whether or not there was adequate time for discovery. Neither party disputes the fact that there wasn't adequate time for discovery. And furthermore, neither party is disputing the record that we have before us. And I might add that on pages 9 and 10 of the record, it shows that Norman himself is directly speaking to confusion as well as Shaggy. And the district court did not act erroneously as opposing counsel argued. The lower court looked at the record and the evidence that was presented to them after discovery by both parties and applied this evidence to the 7 factors for a likelihood of analysis. And they made a ruling that there were no genuine.
Counsel, what you just said sounds a lot like weighing the evidence and making factual findings. It sounds like that's really what the district court did here. Whether the record is essentially complete or not is a separate issue about the proper role in evaluating that record. And I think what Judge Hudas was getting at is, not the completeness of the record, but whether the summary judgment standard was the proper approach here. Shouldn't this be decided either by judge or jury, but at an actual trial rather than on summary judgment?
Your Honor, they did. Your Honor, the lower court looked at the 7 factors and applied the law as to the record we had here. There was very little fact finding by the lower court. And furthermore, this court can only overturn a grant of summary judgment if there was clear error. And there was no clear error in the findings made by the lower court, because the factors do overwhelmingly weigh in favor of Shaggy. They do support that there is a likelihood of confusion. And furthermore, as I stated, there's actual evidence of actual confusion. And while circuit courts have stated that evidence of actual confusion is not required, it can be highly probative of a likelihood of confusion. And the Sixth Circuit has stated that evidence of actual confusion is the strongest proof of likelihood of confusion. And as I said,
well, wasn't there only 2 or 3 instances where customers mentioned the Norm dog food? That seems to me to be a rather de minimis number of cases for actual confusion. And why does that weigh so? If the court is weighing that so heavily, again, going to Judge Thurman's concern, why is summary judgment the right vehicle for making this decision when the court is essentially weighing this particular fact so heavily?
Yes, Your Honor. The record, the instances of confusion are not de minimis here, because that is all we have before us. The record is the record we have before us states actual consumer confusion that hasn't in fact occurred. We don't have evidence of any other sort of confusion. However, what we do have, unlike other analogous cases, is that we have both Norm and Shaggy admitting to consumers being confused as to an affiliation between the marks. We have people coming up to them in person wondering why they aren't selling each other and promoting the other product, because in fact, Norm has stated multiple times on the record, page 9 and page 11, that there were consumers that were confused, but he didn't understand why. But it doesn't matter Norman's intentions here. What matters is that the reasonable consumer was actually confused. And furthermore, as stated earlier, evidence of actual confusion is the strongest proof of likely confusion. And here, not only do we have, this isn't just pure anecdotal accounts of consumer confusion. We have actual consumer confusion that's on the record stated by both parties.
Excuse me, counsel. I think we get that there's been actual confusion. It's not the law that's determinative of likelihood of confusion. It's a factor. I find the marks make a different commercial impression. I might want to reverse on that point. I think that NORMM is not a word. It doesn't mean norm and it doesn't mean normal. It's an acronym for natural, organic meat meals. And I would assume that since that was actually the name of her company, her acronym would be perceived that way. Whereas the new norm was a reference to somebody who was offering actual personal services. I mean, the connotation of norm as someone's name would be directly linked to the source of the physical fitness services that were being live streamed. I mean, what you see on his blog, that is ancillary to his service. So if in one case norm means a person, and if in another case the norm is an acronym, perhaps the district court erred.
Your Honor, the district court did not err, because connotation is not weighed. The importance of connotation in determining whether the sight, similarity, sound of a mark does not get weighed heavily. The reasonable consumer doesn't know that norm is an acronym for natural, organic, and real meats meals. While page 6 of the record says that the mark norm is registered to that LLC, the trade dress at the end of the record indicates that her brand is just Norm, NORMM, and acronyms typically do have periods between each letter, but there is no indication of the words natural, organic, and real meats meals on Shaggy's packaging with her mark. Her mark is Norm. And furthermore, in addressing your concern about Norman's mark speaking towards himself, Norm, again, the consumers who don't know that the new norm is in regard to Norman or Norm. Not every consumer would know this. And Again, there are
Excuse me, counsel, are you telling me that people who take a physical fitness class with Norm have no idea that Norm refers to him?
Your Honor, I'm not actually saying that. What I am referencing is that the record indicates that the majority of Norman's sales are to online individuals. We are in the middle of an epidemic where his classes are socially distanced and have a limited capacity. And he's made $3 million as indicated on pages 9 and 10 of the record, but each class is only $100 to stream. Therefore, the majority of his consumers are online, and they might not make that affiliation. They may tune in halfway through. They may not have the sound on. They may be there just for the exercise classes with their dogs. And so we can't make those assumptions about whether or not what the consumers may conjecture when it comes to hearing the new norm. However, we do know that the marks are similar, and Norm is fully encompassed in Norman's mark, the new norm. And this further goes to my third point, that Shaggy's federally registered mark is distinctive and strong, and Norman intended to benefit off of that mark. Federal registration of a mark is prima facie evidence of the validity and the inherent distinctiveness of the registered mark, as stated by Section 1115A of the Lanham Act. And the scope of protection that is given a trademark does depend on the strength of the mark, with stronger marks receiving greater protection, as the Ninth Circuit stated. And a strong mark is inherently distinctive. Therefore, it is more likely that consumers will be confused to another's use of the same or similar mark. And pages 5 and 6 of the record state that Shaggy's mark was not only federally registered, but she maintained her registration between the 5th and the 6th years, filed an affidavit of incontestability, and thus her registration is prima facie evidence of her mark's inherent distinctiveness, which garners her mark greater protection under the Lanham Act because it is strong. And the Sixth Circuit—
Well, hold on, that's two different ideas. I mean, the registration says that it's inherently distinctive, but there's a range of strength and weakness within distinctiveness.
That is correct, Your Honor. There is a spectrum ranging from fanciful and arbitrary to generic. However, a mark that has been registered with the USPTO is presumed to be at minimum suggestive. And furthermore, she did file an affidavit to incontestability, which means no one has opposed her registration in over 5 years. And the Sixth Circuit has stated that a federally registered mark that has not been successfully challenged within 5 years is deemed an incontestable mark, which courts presume is conceptually strong. So that conceptual strength is not what is at issue here. She does have a strong mark, and because her mark is strong, she does garner more protection because of that inherent distinctiveness of her brand. And furthermore, the 11th Circuit recently held in December of 2020 that a plaintiff was properly granted summary judgment on its likelihood of confusion claim because of the majority of the factors weighed in their favor. Those factors weighing in their favor included strength of the mark, the intent of the defendant to misappropriate goodwill, the similarities of the mark, and the similarities of the customer base. There was no actual confusion in that case, but yet they still deemed summary judgment necessary. And this case is more than analogous to that case, and that we also have actual consumer confusion. So we do have 5 factors weighing in favor of Shaggy, and not to mention the intent of Norman. He did intend to show affiliation as indicated on pages 9, 7, 8, and 9 of the record. And for these reasons, because we have Norman's intent and because the factors do weigh in favor of Shaggy, we respectfully ask this court to reverse and to affirm the district court's order granting summary judgment because there are no genuine issues of material fact. Thank you.
Good afternoon, Your Honors, and may it please the court. My name is Matthew Griffith, and I also represent the appellee, Shaggy. I will be addressing the second and third issues, the first of which is that the defendant's infringement was willful, and that because of his willfulness and the unjust enrichment created by his actual confusion, disgorgement of Norman's profits was proper. The district court thus correctly concluded that Norman acted willfully and awarded summary judgment and disgorgement of profits, and our court should affirm those decisions for 2 reasons.
Counsel, before you go any farther, I may have missed something there, but I think I heard you say that your argument is that the profits award is justified as on the basis of unjust enrichment. Is that your sole basis for the award? Are you?
No, Your Honor. We would ask for disgorgement based on the need to deter a willful infringer, coupled with his willfulness argument, Your Honor. I'm sorry, I should have bridged that gap a little bit better, but there are 3 avenues for disgorgement of profits, one of which is unjust enrichment, and I just wanted to address that at the outset as well.
Counsel, you made the argument that because there was a finding of willful infringement, it seemed that you were saying automatically defendant should disgorge profits. Are you saying that a finding of willfulness by itself is a reason to disgorge profits?
No, Your Honor. In fact, the willfulness requirement was, as opposing counsel pointed out, removed under the Romag Fasteners decision last year for 1117A. However, Justice Sotomayor did maintain that willfulness is still an important factor to consider for disgorgement of profits. And
right.
Yes,
so if willfulness is part of a larger set of factors we look at, what besides willfulness in the record would justify our upholding a disgorgement of profits?
Well, Your Honor, the infringement by Norman also, another way for disgorgement of profits is unjust enrichment, and the actual confusion that was created through Norman's actions opened the door for disgorgement of profits, because the idea behind the Lanham Act allowing disgorgement of profits is that equitable relief to prevent future infringement from whether it be willfulness or bad faith, and actual confusion and that unjust enrichment is just simply an alternative avenue for disgorgement. So,
all right, so you have what I'm trying to get at is what facts in the record justify this. So you mentioned actual confusion and willfulness. What other facts in the record would justify the disgorgement of profits?
Well, Your Honor, Norman found out about if you look at page 7 of the record, Norman found out about the Norm brand through the same social media sites that he advertised on primarily under the pandemic times. One of our circuits has decided that geographic overlap and substantial social media overlap favors the plaintiff in a disgorgement of profits case, and that's in Fleet Feet Incorporated versus Nike. Your Honor, I would also point out that Norman showed through his discussions with his dog on page 6 of the record that he was acknowledging, here comes Norm with your Norm. He's acknowledging that the dog food brand itself was helping his dog lose weight, which prompted him to create the workout regimen.
Excuse me, counsel. What exactly is the link between him talking to his dog and finding that the dog was losing weight through her food?
Yes, Your Honor. On page 7, he realizes that his exercise regimen could be created for dog lovers specifically. And the idea stems from his Norm with the Norm remarks with his dog. It evidences that he is acknowledging Norm is a dietary dog food. He gets the idea to start his workout regimen implementing that dietary dog food, and expressly uses that brand, name and all, in his advertisements and in his exercise regimen.
I thought it was a single mention in his blog of the Norm dog food.
He also gives out recipes at his brick and mortar store
But those don't refer to Norm.
Your Honor, I believe that when he hands out the recipes, they do have the Norm dog food specifically on them. I'm looking for that site in the record.
That's okay, counsel. You can move on.
All right. Thank you, Your Honor. So while there is ample evidence to support what would amount to willfulness, there is a need to address willfulness as a definition. It's not a defined mental state, and while Romag did decide to remove the willfulness requirement for disgorgement, it failed to properly define what willfulness is. So the circuit split that existed pre-Romag remains. However, circuits have found that actions amount to willfulness when they are intentionally deceitful to customers, as my opposing counsel pointed out, but also willful ignorance or willful blindness has been held to be equivalent to willfulness. In fact, the case that cited this was in the Ninth Circuit in Comics versus Towley. The defendant there was, and they quote the language from Lindy Penn, was clearly calculated to exploit the advantage of an established mark. However, it wasn't an intentional ruling that they used. It was his willful ignorance or willful blindness through his actions of using the Batmobile brand. In that case, he was creating Batmobile replicas using the Batmobile mark intentionally, but that's not what they ruled. They ruled that it was willfully turning a blind eye to the need to properly conduct that registration search. And so that case evidences a lower standard that I believe that Norman, if not acting intentionally, certainly meets that willful blindness standard. Also, the case that was cited by opposing counsel, that four-pillar dynasty decision, does articulate the intent factor. However, in that case, the defendants were acting very similarly to this case here. They evidenced bad faith by showing a failure to respond properly to a cease and desist letter. And in that case, in fact, it was upheld, the district court's decision was upheld to disgorge their profits. So the case there, they were using they received a cease and desist letter, failed to respond accordingly, and were found to have acted with the intent enough to have been willful and have their profits disgorged.
Counsel, I'd like to follow up on that a little bit. If we find that at the point the cease and desist letter was received, that information plus the actual confusion incidents, at that point, let's say we agree that Norm was being at least willfully blind, and therefore we can find the infringement from that point forward to be willful. If we reverse as to willfulness prior to that point in time, should we affirm the $3 million disgorgement remedy?
Yes, Your Honor, you should still affirm that $3 million because the willfulness remedy begins at the moment of use of the mark. And Norman was using the mark the entire time. He had been using the Norm mark from the outset, and the bad faith.
But as your opposing counsel pointed out, we have to administer these remedies, particularly an award of profits, in an equitable manner. What if he earned only 100,000 of the 3 million in profits after he realized that there was an infringement? How is it equitable to disgorge all of the profits in that scenario?
Well, yes, Your Honor, it is an equitable remedy for disgorgement of profits. However, the disgorgement of profits is given to deter future willful infringers. And if willful infringers, if it were thought of by future infringers that they could get away with it for a certain amount of time and then eventually get caught and only have to give up a portion of their profits, that wouldn't really be as deterring or as big a deterrent as if you measured it from the beginning of the infringement. Moreover, the cease and desist letter and bad faith element is only something to show, it evidences more of a need for disgorgement, and Norman was acting already from the beginning willfully needing disgorgement. And moreover, as Your Honor correctly pointed out to opposing counsel, Norman had ample opportunities to correct his continued confusion, and yet he chose not to. Internet disclaimers could have easily been amended to his website, but Norman elected instead to address only in-person questions, which were sporadic and not the primary basis of his sales and of his profits. And that's only further evidence of his bad faith in hiding the ball. According to page 7 of the record, as I previously cited, Your Honors, Norman learned of Shaggy's Norm brand well before he decided to begin his own business. As a result of the learning of that Norm brand through Face Diary and through Photogram and expressly advertising on those sites, it evidences his clear, if not intent, then willful blindness to the need to conduct a proper trademark search. On page 7, it simply shows, 7 of the record, yes. It shows that he asked friends and got thumbs up emojis. That's page 8, in response to his question about his idea for the new norm, which is far from a proper conduct for a trademark registration search. And again, in citing that Nike decision, the Fleet Feet versus Nike, substantial social media overlap such as that with substantial geographic overlap in the brick and mortar store that Shaggy owned just down the street is evidence in favor of the plaintiff. The Lanham Act further allows, besides deterrence of a willful infringer, the Lanham Act further allows disgorgement of profits through unjust enrichment. And as was properly pointed out, there was evidence of actual confusion. My co-counsel addressed actual confusion. Your Honor, did you say something? Okay. As my co-counsel pointed out, there was ample evidence of actual confusion, and thus unjust enrichment is highly is evidenced. The 10th Circuit in Western Diversified Services versus Hyundai Motors explained that unjust enrichment allows for a disgorgement of profits. The 8th Circuit took that and further explained that actual confusion is a highly relevant consideration for unjust enrichment, and that came out of Safeway Transit in the 8th Circuit. That actual confusion, coupled with the willfulness requirement, opens 2 avenues for disgorgement of profits, Your Honors. Both avenues should be affirmed. The record on page 9 shows that customers believed Norman was affiliated with Shaggy. And as mentioned before, those confusing questions could have been quelled through a simple disclaimer online. He could have referred them to that disclaimer that did not exist. That mistaken belief led to his unjust enrichment in the amount of $3 million.
Excuse me, counsel?
Yes, Your Honor.
I'm having a bit of a hard time with you are attributing responsibility for a trademark attorney level of knowledge of trademark law to fitness, exercise. If the only confusion he knows of is through individuals and there isn't any confusion caused by his website, why are you saying that willfulness is shown by his failure to correct his website? His website had nothing to do with it.
Well, Your Honor, the primary source of his profits was the website. So if he was put on alert by those in-person people asking about the confusion, then it's a reasonable person, which is the standard, a reasonable person.
Well, when you say it's through his website, I mean, isn't it his actual, I mean, that's just because that was the source of the live stream. The service is actually what Norman did, right?
Yes, but it was in his brick and mortar store that the confusion was brought to his attention just down the road from.
And he addressed it promptly and thoroughly each time.
He did individually, Your Honor. Yes, I do concede that. However, reasonably speaking, it would put someone on notice that there is confusion being caused here. And if even if he didn't have the sophistication to conduct a proper registration search, reasonable people would have at least taken further steps to alleviate.
But counsel, we've said that he had profits of $3 million. Yes, people paid $100 to have his services. So he clearly had thousands and thousands of people participating, and yet he only had a couple who noted any connection. And wouldn't it be reasonable for him to conclude that those folks were maybe just easily confused, or that they were not typical of other consumers?
It could be reasonably concluded that way, yes, Your Honor. But in order to protect one's business, even without sophistication in the business, to cover your basis, a reasonable business owner would take at least proper steps to consult with counsel, which Norman failed to do, or respond to the cease and desist letter, which Norman failed to do. And the cease and desist letter only further amplifies these apathetic decisions being taken by Norman. Your Honor, I see that my time is up. May I briefly conclude?
You may.
Your Honors, infringement should not be profitable. Norman acted in a way that amounts to willful infringement. And furthermore, he was unjustly enriched through the actual confusion. Therefore, the summary judgment afforded and the disgorgement of profits should be affirmed by this court. Thank you very much.
Your Honors, may I proceed?
Yes.
Your Honors, one point on rebuttal. Opposing counsel put a lot of emphasis on evidence of actual confusion. However, the record only shows anecdotal references and does not show a substantial number of consumers being confused to suggest likelihood of confusion. And if this court believes this factor is important, this case should be remanded for a jury to decide that fact. Counter to opposing counsel's statement, the appropriate standard of review here is de novo, not clear error. Thank you.
The judges will now retire briefly to deliberate. Please remain in the courtroom and they will return shortly to critique the arguments. Court of Appeals is now in session.
Okay, on the comments, my co-judge has asked me to go first, so I shall. Mr. Pure Bryant, you started off really strong, but I had asked you a question on comparison of the marks, and I believe you said that not any one factor could show a similarity. That's not the law. You can have similarity of the marks found if there is a similarity of appearance, meaning, sound, or personal impression. So any one of them can result in a finding of similarity between the marks. Mr. Jacobs, you started off a little weak, but you got really strong as you kept going. And I liked your argument. Miss Neal, I'm going to give you the same advice my moot court coach gave me 30 years ago. Slow down. You were going really fast, almost not even taking a breath. So it was really hard for us to interject and ask you questions. You made a concession. I don't know if you meant to, that the judge on summary judgment made very little fact finding. I don't know if you meant to say that, but that's what we heard. When you're trying to support the judge on summary judgment on appeal, that's not something you wanna say. So, Mr. Griffith, you started out really strong, but when Judge Dunn started peppering you with questions on record, you started getting flustered. Practice in moot court, and then when you get in the real world, is you got to learn to go on your argument, but be ready if a judge asks you pointed questions about the law of the record, you got to be ready to answer them and then get back to your argument. All right, that's my comments. Thank you very much.
Well, I'll go next then. So I thought all four of you really did a very good job. I appreciate your professional demeanor, and I thought all four of you knew what your strongest arguments were and repeated them. Sometimes a little bit too much. Mr. Pure Bryant, you're right, the summary judgment standard very much favored you, and so you know, when there was facts that you didn't like, you said, well, then let's send it to the jury. But you know, you had a lot of facts that were in your favor. So I would say, while it was strong to recognize your best argument, I would have, in terms of time management, I think I would also have liked to have seen more discussion of the likelihood of confusion factors which favored you, because, you know, you were given some. But I thought knowing your best arguments and turning your a pointed question around to go back to your strong points, I thought those were excellent skills, and you did a very good job with them. And Mr. Jacobs, I thought as a team you showed a lot of the same similarities. I mean, know your arguments, try and turn every question to your advantage so you don't lose any momentum. And a very strong conclusion. I liked that very much. Let's see. So Team Shaggy, Ms. Neal, again, you know, actual confusion. We don't always get it. It is good evidence, but I felt like you leaned on it a little bit too much. That when we were asking about different factors to say, and there was likelihood of confusion, that's a little bit shortchanging the other evidence in the record, which you could have gone on. You know, trademarks is a very fact-specific area. The judges like to hear the different facts. I mean, turning to the legal standard, we're familiar with the legal standard. And the fact that there was actual confusion, we all knew that. I think a little bit of overemphasis there, but again, it was a point in your favor. And Mr. Griffin, I did I did lean a little hard on you there. I hope you are not feeling too bruised. But the the point about the advertising on the blog, you were wrong about that. I mean, he didn't use her mark to advertise his food, which is but we moved off that. I said move on, and you did, which was good. I mean, nobody's perfect. Things happen, and that's the best you can do, is not let it rattle you, but move forward. And so, good work on that. Oh, and I found you a little fast in your delivery, but again, that may be mean of me to say so, since I was asking you a lot of questions. So enjoyed the arguments very much. Thank you.
Hi, I guess I'll chime in. I'm third in row here, and everybody has so far said what I was thinking. I do want to say unfortunately, my screen, my transmission locked up, so everybody was frozen, and it was a little bit distracting. But overall, you all have such a professional demeanor, and I could tell how hard you all worked. I don't know if the appellee's team thought of this, but one of the things I picked up on is, you referred to Shaggy as opposed to the appellant's real name, and I thought it was maybe kind of a softer way, a less harsh way of coming across as the plaintiff. And I don't know if that was intentional or not, but I thought it was kind of clever. I don't know that would work in another scenario in real life, but for here, I thought it was it was just a little detail. And I thought that both Ms. Neal and Ms. Griffith, you were able to recover after some questions and get back to your main, the points you were trying to make. That was good. Regarding appellant's team, Mr. Bryant, you, as Judge Dunn mentioned, you were focused on the standard. You did some. I wrote a note about. You mentioned something about based on the name of the business. You conjectured what that would mean to the consumer. The whole the new norm, what that would mean to the consumer, and I thought that was a clever argument. And Mr. Jacobs, I think you did a very excellent job. You had a good intro. You referenced the standard, which I think was not talked about enough in my view in the papers. So and then everyone was very familiar with the record, and that's really important to be able to point the judges to what you're talking about. So good job all around, and thank you for your efforts.
Okay, well, I'll give a few kind of closing comments. Again, this is going to sound repetitive, but it's really just because it's true, and that is that you all did an excellent job here. This is something you're going to remember probably forever, and it's a phenomenal experience. I can't compliment you enough on putting the time in. I did moot court for 2 years in law school. I liked it a lot, but I know the time that it takes. So really hats off to all of you. There was a definite difference between the two teams in this round in terms of sort of the timing and pace. The appellant team, the New York team, they took things a little slower, and they seemed to kind of be listening a little bit more and engaging a little bit more carefully with the panel. The appellee team, and I think part of this is just because when you're the appellee, you're sitting there listening to the other side, and you're probably getting more and more fired up about all the things you want to say in response to it. But there's a tendency, I think, to come out with too much of a head of steam. And we kind of saw that here. I think both of you, Ms. Neal and Mr. Griffith, you both really kind of barreled into your arguments and were, kind of rolling through things really quickly. You want to take it, take a breath and slow that down enough, because at an argument, whether it's a hearing at a district court or like this is supposed to be an appeal oral argument, you're only going to help the judges if you can actually engage with them and have some back and forth with them. So when they start asking questions, you got to kind of dial it back enough to be able to get into that engagement. For the most part, I think all of you did really well in that. But I do think that Ms. Neal and Mr. Griffin, like I say, you guys kind of came on going really kind of fast, as Judge Hughes said. And again, some of that is probably just from where you're sitting, in the appellee position. That's a natural tendency. There are some substantive things. I'm not really going to go into those. I mean, you guys are law students. I think your command of this area of the law, as well as the procedural issues, because ultimately this problem ends up being as much about procedural stuff as it does about trademark law. And your command of all that was just exceptional. So congratulations to all of you, both on getting here and the performance you did before us today. So thank you.
Okay, so after this, if nobody has anything else, please log into the awards ceremonies link, and we will be able to start that as soon as all the other courtrooms are done. Thank you.
Thank you all. Thank you. Thank you all.
Thank you.
Okay, so I see you guys in the ceremony. Bye-bye.
So will we go to a separate link? Do we?
Yes,
yes,
there's a link for it's Courtroom 1 for the ceremony.
Okay, do we leave Zoom and then reconnect to Zoom?
Yes, because
okay.
Yes.
Okay, thank you.
You're welcome. Thank you, Juliana.
Thank you very much, Verna.
Okay. Bye, Elizabeth. Thank you. Okay.